Hello, everybody, and welcome to Wealth, Wills, and Trusts. Just so you know, I am a Florida attorney. I've been practicing law now for over 17 years. Time flies so fast. And my duty to you as a member of the Florida Bar is to educate you, to empower you, to help you make decisions that are better for you and for your family. So let's get started. Um, just so you know, I am a mom. I'm an author. I've written 4 books, and I own the law firm LCO Law. And the reason why I do this, why I do these educational webinars, is because I have seen the side of conflict for the people that don't plan. I handle it, right? Half of my practice is litigation, and the majority of the real estate litigation and probate litigation that I handle is because a loved one failed to plan, or they only planned have bottomed, let's call it. But these lawsuits create problems that go beyond the cost of litigation. Siblings don't talk to each other. There's taxes that don't get addressed, and then tax penalties that come out of that. And then when money ends up in the wrong hands or at the wrong time, what you thought you were leaving behind is just lost. So I don't want that to happen. And this is why I do this. Okay. As Justin mentioned a little bit earlier, please type your questions in the chat as we go. At the end, I'm going to answer as many as I can. Like he mentioned, also respecting people's time, because we know that while we appreciate you've made time to come here today to learn about how to empower yourself and your family, you also probably want to go have dinner and relax and all the other things that bring you joy. We have this webinar as a interactive webinar. Okay, so we're going to give you some tools. There are going to be some things here that will help you have better conversations with family about those details that sometimes we forget or don't even know that we should be discussing as part of our planning. One of them is a legacy leak test. All right, so let's start out with who benefits from estate planning. Everyone benefits from estate planning, but really, if you're married, you're not married, you own a business, you have blended families, which, by the way, is more than half of the United States now. You are a widow or a widower, and maybe it was sort of easy when your spouse died, but it was very, very different afterwards. And you might be part of the sandwich generation, right, where you're taking care of some minors, maybe young adults, and now you're starting to take care of mom and dad. The idea is that if you want protection, stability, you want to preserve your own independence, you want to reduce risks, then you need to engage in a plan. So here are little exercises, okay? I have exercises because I want you to think through, what are your gaps? What are the gaps in what you should be doing, the conversations you should be having? And so Julie's going to put in the chat a link for you to be able to answer these questions confidentially, okay, for these exercises that we're going to do. But before we start these exercises, I have a very important question to ask you, okay? Put a 1 in the chat if you think you have a simple estate, okay? This is a very common comment that I get, that they think they have a simple estate. And so I want to get your opinion. Put a 1 in the chat if you think you have a simple one. Okay. All right. Here we go. Are we ready? So first one, we're going to talk about your incapacitation. Okay. This is if you couldn't speak for yourself tomorrow. And why couldn't you? Maybe you had a terrible car accident. Maybe you're hospitalized, or maybe you're suffering from diseases that affect your memory and your ability to make decisions for yourself. So incapacitation, okay? So number 1, who would care for you? Who would care for you if you were incapacitated? I ask this because almost every one of us has somebody in our family who would eagerly raise their hands, and we would not want them to ever get involved in our decisions. We have very big conflicting views on things. And so you need to be mindful that there is nothing in the statutes that says these people have, like cis person and then a cis person. That doesn't exist. That's a kind of like a myth that people think out there. Oh, it'll be my spouse first and then my parents. No, there's no such order or preference. Number 2, These people, do they know where your assets are? So let's say it's a person that you trust can take care of you. Do they know where your things are? Because if they don't know where you have investment accounts, bank accounts, retirement accounts, resources to be taken care of, it's going to be very difficult to provide you with the care that you need at the time that you need it. And more importantly, if you don't have a plan in place, do the people that you trust, that you think would raise their hand and do a good job for you, do they have the money or the right to step up and take care of you? Because the thing is, if you have to do it through court because you haven't done planning for incapacitation, court can become very expensive. And we'll talk about that later. But I just want you to understand these are some gaps, some things I want you to think about. Okay. And just food for thought. Do you all have any idea how many laws there are in the state of Florida regarding incapacitation? Right. 200. There's over 200 statutes that deal with incapacitation in the state of Florida. So it's not something that can be easily mastered if you've never tried it before. All right, number 2. This is for you that have either minor children or you have elderly parents that depend on you. Maybe they just moved in with you. Maybe you have to go check in with them frequently, or maybe they are at an advanced stage where they really are relying on you for most of the care. But if you're working late, who watches them? And then more importantly, would they know who to reach out to if they can't get a hold of you? Number 1, police. Police in Florida have no organized statewide system on what to do. Every single sheriff's office that we've dealt with has a different practice, a different policy, and it can also vary on the day of who's managing that evening. So it's very important to understand that leaving it up to the state is going to create some chaos, right? Your children can end up in the Department of Children and Families. Adult Protective Services can come in, and that's very, very difficult to deal with, whether you're a child, right? Because, my God, the chaos of not knowing where your parents are. And then if you're an adult who has advanced needs, being pulled into a different place can be so jarring, so confusing. And so you don't want to depend on doing nothing to protect the people that you love that depend on you. Furthermore, with respect to the people that you might go, you know what, this would be a perfect guardian for my children. I'm going to go talk to them. I think that they understand my values. Do these people have access to finances to support your children? Would they? How easy would it be? Or would they have to go through probate administration, maybe through guardianship administration if you're stuck hospitalized for months, which I have clients who have told me they had these conditions. So if you haven't had these conversations, please do so, because these are important gaps to address. And just food for thought, okay? 3 kids in every classroom will lose a parent by age 18. That's reality in the United States. And I'm not like, this isn't a myth. Yes, last year I helped chaperone my child's little 5th grade class trip. And one of the girls I was assigned to had lost her father the year prior. This is reality. So as much as we hope nothing ever happens to us, we need to acknowledge the reality that it just might. Number 3, okay? Death. We have to acknowledge it, address it. What would happen the day after you die, right? So similarly, who's going to step up to handle things? You might have that very, like I said, like intrusive loved one who just wants to get involved, wants to control everything, or maybe wants your assets. But if you leave a blank, the judge can consider whomever raises their hand to participate. And then again, if it's somebody you trust who would raise their hand, do they know where your assets are? We are deeply private individuals. And if we don't have an organized system that has everything that we own, lets them know what resources, what assets we left behind, people are going to be stuck looking for months. This is one of the biggest reasons why probate takes so long, is because the people that are appointed to these roles have no idea what you have, and they have to dig through mail and hope the best that they find it all. Do they also know how to find your heirs? You would be surprised how many people have half siblings that maybe they didn't talk to, maybe the spouse didn't even know about it, but these are potential legal heirs that exist. It's reality. And so we need to be candid in our planning about everybody who is potentially a beneficiary, and how do we remove them from this if we don't have a relationship with them, if we don't want them to benefit from whatever we leave and create behind. And then, do they have money to hire a lawyer? Because if you don't have a plan, if you're relying on the state and probate administration, it is going to cost quite a bit of money to hire a lawyer to open probate. This is why a lot of money, a lot of resources get lost to the state. People don't have the resources, people didn't have the money, bam, it's gone. Okay. The right person can also be blocked by the court. And this is because they might be, again, blocked out due to costs. They might live in the wrong state. And so understand that just saying like, oh, here's what I want, and I want you to be the person, that doesn't work. That's not legally enforceable. You have to do things the right way. And then finally, just in case anyone wants to know, how many statutes govern your death in the state of Florida? At least 345. Yeah. So with that being said, knowing and understanding some of the things that you should be having a conversation about with your loved ones, finding these gaps, let's go to the reality, okay? Because gaps put your family here. And this is why. There are 659 statutes that affect incapacitation and death, and 754 pages of rules regarding the administration of those statutes. I call this over 1,400 opportunities for mistakes and conflict and loss. And it's very sad, but families end up here for that reason. That's why improper planning, DIY, doesn't work. I think most of you would prefer your family to be here, right? Happy and confident and getting things done privately through a lawyer's office, rather than having to go to the court system, face a judge, which can be nerve-wracking for most people because you don't deal with judges on a daily basis. And so to prevent that, you got to plan. Okay. All right, let's talk about common cheap planning mistakes, because God bless them, people try different methods. One of them is adding their kids to title, right? Joint tenancy with right of survivorship. I'm just going to add Sonny Boy here with me, and when I pass away, he'll just have it. Okay, great. You just opened up your property that you added him to his creditors. Yeah. You also just gave him full authority to block you from being able to refinance your house, to sell your house, to lease your house, to do anything that you need to do with it, because you've given them title. And you've also made them lose capital gains tax benefits that they would get if they received it at death and not as a gift during life. You've also triggered a gift tax return because you've given them a gift worth more than $19,000. These are all the little nuances that you don't know you're making big mistakes on with just a deed. All right, so let's talk about ladybird deeds, life estate deeds. They're very commonly used, but one of the biggest problems that I see in these ladybird deeds is that they are done without proper counsel. And I can tell you one meeting that I had this week, her father had put her and her brother into this ladybird deed. Father passed away very recently, and the brother is a person with serious mental health issues. Imagine trying to sell a house, lease a house, do anything with a house, having that type of person as a co-owner. And so that is part of the importance of having truthful deep conversations with your counsel so that they understand that the wrong dynamics might signify let's not do that deed, right? Same thing with like just siblings that don't get along. I've had to do a lot of partition litigation due to siblings being put into these ladybird deeds. They were pretending to get along when mom and dad were alive, and that stops immediately once they're gone. Relying on one person being the sole beneficiary and the sole trustee of whatever they've set up. And if you were hoping to get some asset protection for your loved one by leaving them this in a trust, but you've given them full authority to run everything, yeah, in Florida, we've got plenty of case law where creditors can just pierce through that and say, Mr. So-and-so, you control it all. So we're going to grab all these assets mommy and daddy left behind for you to cover your car accident issue. Okay. So cheap planning mistakes really do have a cost. Ultimately, though, what I want you to get out of this conversation is that we cannot go back in time. Okay. My favorite trilogy is Back to the Future. I wish I had a DeLorean. As a kid, I was desperate for one of those. But the reality is these don't exist. We can't go back. And so the only time that we have is now to get things done, now when we have capacity, because once you start having memory issues, once you're gone, you can't change a darn thing. And then ultimately, because you can't go back and change things, right? We don't have like the ghost of Christmas past thing. A lot of people end up losing the ability to receive and transfer these assets. It's cost generally. Going to court is so expensive. And so, these bank accounts that were supposed to go somewhere, yeah, eventually these banks just give them to the Florida Department of the finance department, and then it just stays there. And if it stays there long enough, it becomes part of the state. And I call this the involuntary tax. Now, I don't know about you, but put a one in the chat if you don't want to pay this involuntary tax, if you don't want your family to end up having to pay this involuntary tax. Part of the other lawsuits that I have to deal with is home is lost in foreclosure because dad died, nobody could afford the probate. Home was lost at a tax deed sale because dad died and nobody could afford doing the probate. And if your family can't afford to process the transfer of those things that they left in the hope that they'd be a better legacy for you, they're going to be gone. And it's a very high tax to pay. All right. So we're going to have another interactive tool. I want you to be empowered with lots of tools. So I've created this item we call a legacy leak test. It's 15 very easy yes or no questions. Okay. They're going to help you, again, identify those gaps, have better conversations with your loved ones. And I think, Julie, can you put a little link in the chat for it? The reason why we created this is because even the people that I speak with who do have a plan, which are the majority, people do not. But the ones that I do speak to have critical missing pieces, okay? And those missing pieces result in the conflict, in asset loss, and in also assets passing in a way that they never intended to happen. Those are preventable things. And so, let's walk through this legacy leak test, okay? In this test, there's like a little rubric score, and it'll tell you, you've got some weaknesses, you've got a lot more issues than you thought, or, oh, you better talk to a lawyer now. In it, there's an opportunity to have a legacy planning session with us. What's a legacy planning session? It is a in-depth conversation about where you're at, where your family's at, and it is part of our system for legacy planning. It's not a good fit for everybody, and that's okay. But with this tool, I just want you to find out what kind of gaps you have in place, okay? And if you qualify for a legacy planning session, great. One of my team members will talk to you, but that's not what's important right now. I want you to learn right now. Based on that score, again, legacy planning session, you need to know who, you need to know what happens, you need to know what they would face in court. One of the deeper things that we talk about is how assets can become a burden rather than the security that you were hoping for. because of how you have them titled, because of how you have them held. So these are things that you should be considering in any type of planning. Okay, it is my duty, again, to further the public good, to encourage you to do something. It's okay if you're not the right fit for us. That's fine, okay? We are not the right fit for everybody. For example, if you need a deathbed plan, we're not going to be the right fit because we don't do rush plans. And so that's okay. If you need Medicaid planning, we don't specialize in that, right? We will refer you to an elder law attorney for that. So it's all right if you're not the right fit for us, but you do need to get started. You do need to take action if you haven't done anything for your family. This is a golden ticket. It's just a free 15-minute call to see if we're the right fit for you, if you're the right fit for us, and if our planning system sounds like something that you'd like to use to create your planning. If not, if we're not the good fit, we'll try to give you guidance on somebody that might be the right fit for you. No matter what, we want you to have professional counsel advise you on estate planning. All right. And then, as mentioned, right, it's okay to not have the right fit, but you do need clarity. You need clarity on who you need to talk to. Very often we get phone calls from people that call the office and they're like, oh, I need you guys to do this. And okay, we don't do that. But here, this is the type of attorney that you need. And now they have clarity. Now they have direction. And that's very important. Okay, let's talk about how you plan, what kind of plans are out there and the consequences and the limitations and also the benefits of these different things out there. So number one, we have the Florida statutes, or as we call it, doing nothing, or doing nothing and maybe a will. Okay, that's the Florida statutes plan. So the plan that the state has for you involves opening up litigation against yourself. One is called guardianship if you're incapacitated. The other one is called probate if you're deceased. So if you're incapacitated, just to start out, it's a fee that you'll feel. Average retainer is about $10,000 to start incapacitation proceedings for somebody. And the reason why is because you need a lot of experts involved. It's required by the statute. You need your lawyer, you need a lawyer to represent the person who's incapacitated. You need three specialists, 3 doctors to assess the level of incapacitation of the person. And if you are appointed guardian, now you need a CPA to represent you. So it's a lot of professionals involved and it can become very expensive. One of the other issues about being in court that's a reality, okay, judges can change. And you may have even been in a guardianship proceeding, you may have a couple years taking care of mom, taking care of dad, taking care of your child, and all of a sudden, bam, a new judge. And this new judge has a completely different method of doing things, a different belief system. And that can be very troubling, okay? Because what you thought you could do to help a person out, you can't do anymore. That's just the judge's whim. Okay, it is the most expensive approach to incapacitation planning. I'm going to share a story with you. This is a real thing. So a couple of years ago, a client's child went missing. It was an adult child. This person didn't have any planning in place at the time. So when their child went missing, they had to open up a court proceeding to see if they could get guardianship over this child. It took over 6 months. It took 35 grand, they told me, in legal fees and many, many hours to just get installed as the guardians of their adult child. And then annual maintenance, they give me a little update, it's $20,000 they spent in annual administration of their adult child's estate. So as part of planning, I also want you to remember, age isn't a thing, okay? If you are an adult, a young adult, you're not invincible. And sometimes we forget that when our children turn 18, all of a sudden the state's like, they make all of their own decisions. You can no longer have a say in their finances or talk to their physicians and, do the things that you need to do. So let's try to avoid that. Probate, of course, is when you pass away. That is the state's plan. And probate is required whether you have a will or not. because a will is only a set of instructions for a judge to follow through the administration process. A will has to be admitted to court. It has to be approved by a judge to then be able to act upon it. So in probate court, what do we got? Well, all creditors have first dibs. They're the first in line people. They're the ones that we have a duty to if we're an executor. And if you've got minors, you've got to get conservatorship proceedings in place. And if you've got young adults, goes to them outright because there was no planning involved. There's very little protection in place. And it can become quite pricey for something that we deem a very moderate middle class estate. You can think of it as, let's say, a house. Average price of a house now, or value of a house, is about 400 grand in Tampa Bay. And maybe some retirement accounts. So let's say this person has an estate of 750,000 in total assets. Easily, you can have an attorney charge about 50 grand, and the judge is not going to blink an eye, because under our statutory guides, that's perfectly on par for doing normal administration of an estate that size. So you see why it can be very difficult for families to do probate administration. The other part that makes it very costly for families that they're not aware of is the bond. Okay, I see in wills all the time, and there shall be no bond on my executor. Well, judges can ignore that 100%. Okay, it is a plea to a judge, but judges have full discretion, and every judge recently in every probate case that I've done has imposed a bond. A bond is something that a person has to pay before they're allowed to be an executor. And I'll give you some numbers so that you get an idea, right? So I've one estate where it's about 200 grand is the value of the estate. This executor had to pay an $18,000 bond. I have an estate where I think the value of total assets was maybe 1.1 million. And that person had to pay a bond of $125,000. And then there was another estate just at about $1 million in terms of assets. That one had to pay a $275,000 bond to do the things they needed to do to be appointed as a representative. Again, probate is the most expensive approach. And by the way, guardianship proceedings, they also require bonds. Okay, it's not just in probate at your death, it's also in incapacitation. Okay, let's talk about the second option, online forms. In all of my years of practice, I have never seen a single one without problems. Never. Okay, if you download something off the internet, LegalZoom or lately AI, you are not going to have any idea if the documents are right or wrong, if the people that you put in, you could even put in, or if they're actually barred under the law. And that's painful, okay? Because these are the ones that have to get litigated the most, and fixing is always much more expensive. So I'm going to share another story. A very caring son downloaded a trust form for mom. He's just pulled it off the internet. And it kind of worked while she was living. But guess what? It wasn't properly executed. And Florida has extremely strict requirements on how things have to get executed to be valid at death. And this one stopped working. It stopped existing as a trust as of death, right? So guess what? Now everything has to be probated that they thought was in a trust. And just a couple of months of probate, and it's been well over 20 grand in legal fees. So online forms also end up expensive. And I do want to be very firm with you. AI hallucinates all the time. I was having a conversation with my client today, and she was like, oh yeah, so I ran some of what, created through AI, and it told me so and so. And I said, no, that's not accurate. And just like, you feel kind of like that, oh my God, did I make a mistake? No, I went and looked at the statute. The AI just made complete nonsense up, made different legal conclusions than what the statute actually said. And this is the reality. If you're not a lawyer, you're not going to know how to determine if it's accurate or not, but it does hallucinate quite a bit. I had a litigation proceeding where a young lawyer decided to ask AI to draft her pleadings. 6 cases were hallucinated. None of them existed. None of what they were saying was real. she got real sanctioned. She had to be referred to the Florida bar. So be very careful with that. Fixing, always more expensive. Okay, door lawyers. What is a door lawyer? A door lawyer is somebody who says, oh yeah, we do divorce, we do personal injury, we do real estate, we do business, we do your traffic tickets, we do probate, we do all these things, right? Criminal defense, you name it. That's a door lawyer because they will take anything that walks through the door. Door lawyers know a little bit about all these areas, but they don't know things in depth about any particular area. And as a result, if they create a will for you, a power of attorney, a deed, they're not going to know the nuances of whether it's going to work for you or not. Okay, so big problem. You also will not get support in how to implement these documents. You don't know if they're going to be done well. And I have had problems with door lawyer documentation that we also end up having to litigate. So please do not go with this strategy. It just gets your family ready for court instead of avoiding it like you had hoped. High volume lawyers, these are the other ones. So these are the practices that, for example, all they do is estate planning documents. Okay, great, wonderful, but they're based on high volume. So they don't spend a lot of time with you. They have maybe 2,500 to 3,000 is their average fee for what they call a packet of documents. But because they don't have time, because their bosses require them to do a number of plans a day, they're exhausted. They have limited time to speak with clients. They don't navigate family dynamics. They do not fund. They don't help you replenish or move things the way that they should be so that it would actually work for you. And as a result, you end up with what actually feeds the other part of their practice, which is probate litigation and guardianship litigation. And that's where they make their real money. So it's kind of like, let's call it a loss leader by having these high volume lawyer plans. Then we have big law. Okay, big law is like the Trenum Kenkers and all those big law firms. Now these firms will do a phenomenal job, okay, with estate plans. They take the time to help you select the best people. They help you address tax issues. They help plan for businesses and succession, but they are very pricey. Okay, so the price tag comes with a big law, names that are on the door. Average partner level people will charge about $600 to $1,000 an hour to work on a plan for you. An appropriate plan can take 30 hours or so. So you can kind of imagine what these things cost. But the reality is that if you're not a primo, like up there person with a sizable estate, you're not going to get the partners that have seasoned experience on this. You're going to get their new associates who are exhausted, who have to work about 80 hours a week to get their billables in. And you're going to be dealing with that 2 to 3 year associate who will charge you big law fees, but will not give you big law results because you're not one of those premium customers. And then there's what we do, okay? We do a method that I would say about 700 practices around the country have decided to embrace. A very different system, a system where we spend a lot of time with our clients. In fact, our clients are with us for at least 3 years. And this is because a plan needs a strategy, it needs systems. So not only do we get the time to assess those dynamics and to prevent tax issues and family conflict, we create tools for you. We create training tools for the people you put into these roles. We have such amazing systems in place. And one of my favorite is that we lovingly nag you every step of the way. And I say that because you're busy, right? You might be working, you might be a caregiver, you might be traveling through retirement, but you have other things to do. And so in order to have somebody that supports you in getting things done that you need to do to make sure that your part of the plan gets done, we are there to lovingly nag our clients. And we don't rush you through this because this is important. This is your life. This is your family. This is what you've worked so very hard to acquire, and it deserves that level of care. So some people come to us and they're like, oh, I already have a trust. Is this enough, right? I've reviewed plenty of trusts, and trusts are not a plan, okay? Trusts are an instrument, part of the toolkit that you can use in estate planning. but they're not plans. The number one way in which I've seen that trusts do not work is when they're not funded, meaning nobody put any assets into it. Nobody titled anything into the trust. So what you have is a very expensive paperweight. I've also seen that in those rush high volume firms, there's a lot of mistakes. I've seen mathematical mistakes with the calculations of what goes to whom. I've seen missed clauses. Yeah, I had a lady come to me and she said, "Oh, Natalia, can you review this with me?" I did. And guess what? There was no provision leaving her anything because that was omitted. So upon the death of the first one, what happened? Everything went to the 3 kids. And mom was left without anything due to this fantastic trust. Failing to update these instruments is also problematic, right? Your life changes. Whatever you create, whatever plan you have needs to go along with that. And then, of course, again, if you download things online, if you try to do it yourself, those are the ones that are most easily challenged. One, because generally it's a family member who downloaded something for one of their loved ones. Two, there's no legal advice given in this, so you don't know what you're doing. Again, these are thousands of statutes that are involved and regulations and so forth. And very basic trusts do not have provisions for protecting your children from future creditors, from future divorce, from future lawsuits, from bad decisions, from bad habits. So trusts are not enough. So cheap plans. Cheap plans cost a lot of money, right? That 55 grand in about a year worth of guardianship proceedings, losing capital gains tax benefits that you would have had you just left it the right way to your children, your kids ending up in the wrong hands at the wrong time. Because if your kids lose you, that's going to be the worst moment of their life. Nobody forgets having lost a parent under the age of 18. And that disorientation of not knowing who you're going to be with, being potentially with strangers for God knows how long, you don't want to leave that to your kids. And then again, the wrong people getting involved. I remember how I mentioned that I had that conversation regarding that Lady Burdette and her being put in deed with her brother, who is not mentally a healthy person. He was the one that dad named as first in line for everything because he was just the one that lived nearby. So, as we say in Spanish, lo barato sale caro, okay? Cheap is expensive. We have to be mindful of how we invest our resources in protecting ourselves and our loved ones. And always, always have lawyers prepare this for you, okay? Okay, so taxes are very important. Taxes are one of the biggest concerns that people bring to me when they're talking about estate planning. I have a master's of law in taxation, so I have additional planning, taxing training that only about 0.2% of lawyers have in the state of Florida. Attorneys that don't understand tax issues can get you in trouble. And while the estate tax may not affect most families, thank goodness, knock on wood, income taxes do, okay? Estates have income taxes. And if you have somebody that has no idea how to advise you on how to properly account for those retirement, investment, rental home, business income that's coming in, right? That is going to be subject to taxes, that is going to require a report, and your counsel has no idea how to communicate this to the CPA or what to bring up or what can maybe be a deduction, you're going to have problems. And this is why it's so serious, because under the Internal Revenue Code, if you are an executor of somebody's estate or you are the trustee of somebody's estate, you have personal liability for the taxes owed by the estate or the trust. Personal liability. This means that they can go after your assets if it's not done properly. So this is why having real counsel that understands this is so key. The legacy planning session, we talk about those tax things. We bring it up immediately. When I'm reviewing what my clients submit, because we give them the opportunity to complete what's called the 22 critical risk factor worksheet. It's unique to us, but it helps me understand really where the family's at. Not only what they have, but values, who's involved, who's at risk. We talk about those tax issues, not just how they can affect you at death, but now we talk about risk factors for your assets, not only at death, but now. So this session is beloved by my clients because they get clarity that they've never had before. I had a couple come in this week, and the gentleman was dragged in by the mother of his child. And by the end of it, he was like teary-eyed. And he said, I don't know where my wife found you, but oh my God, I'm so glad we had this conversation. There are things that legal counsel can talk to you about that you just didn't think about before that are really essential to discuss. There's the golden ticket. Again, it's an offer for you if you want to find out if we're a right fit for you, or maybe get a referral to a place that's a better fit for what you're looking for and what your needs are. Remember, okay, you're not going to be a good fit for us if you need a deathbed plan, if you need Medicaid planning, if you want your lawyer to act as your trustee or as your power of attorney agent or your executor. We're also not a good fit for that, okay? I will not accept the role of doing that for you. I want to remain neutral with respect to that and your advisor, not somebody that can act on your behalf. That's not what I want to do, okay? A lot of attorneys out there are willing to be the executor of somebody's estate. Not me. I have very strong, clear ethical boundaries. If you're somebody that wants to do joint planning with non-spouses, we're also not going to be a good fit for you. I'm very inclined to embrace that attorney-client confidentiality, that duty of loyalty. And so if you're not married to each other, joint planning is just not going to be something that we're going to offer you, okay? But like I said, there are other people out there for which, if those are your needs, your desires, they can be a good fit. And if we know somebody, we will help you and get you that information as part of our communication with you, all right? Okay, let's talk about these myths. Number one, estate planning is only for the wealthy. I understand that we have this perception that we don't have a lot, but the reality is that all of us have worked very hard for whatever it is that we've decided to pass on, to lose it to conflict, to lose it to hefty court fees. And planning is far, far cheaper than going to court proceedings, okay? Proper planning that doesn't just rely on a will that shifts you right into court, will help protect you. Who has heard about the issues with Princess Estate? You know, like Prince, the artist formerly known as Prince, he died very suddenly, okay? He didn't have a plan. And his estate was valued at about $156 million when he died, okay? So why are we talking about this, Natalia? We're nowhere up there. It's okay. He didn't have a plan. Because he didn't have a plan, his estate had to deal with 6 years of litigation. 6 years of litigation. Now I'm going to ask you all a question. Do you think it cost more than $10 million to administer that estate, or less than $10 million? If you think it was less, go ahead and put a 0 in the chat, okay? Less than $10 million to administer his estate over 6 years. All right, Julie, you think it was less than 10 million? Okay. I mean, $10 million is a lot of money. It was actually $80 million. $80 million. So his family ended up with 49% of what he left behind because of not planning. I'm sure that you do not want your family, right, to lose 51% of what you're leaving behind, but that can be the reality for you as well. Because sometimes when families can't afford, they don't have the cash, right, to open up probate proceedings, they will have to go with a contingency lawyer. And contingency lawyers charge 30 to 40% of the assets of the estate. to do it for you. Why? Because they're acting as your bank. And it's a very expensive bank. It's like bookie level of bank. But that's real. And that's one of the few ways that people are able to open up any proceedings if they get stuck having to go to court. The other myth I want to address is about, oh, my spouse is going to get everything automatically. No. Like I mentioned earlier, the majority of us are blended families in the United States, and our codes are not written for blended families. So if you have a spouse that has a child from a prior relationship, you will not get everything. Okay. And you will get some things in a very painful way. Um, one of my clients a couple years ago was such a sweet gentleman. I came in because his original probate counsel wasn't moving things fast enough for him, and he was suffering from pancreatic cancer. And his wife had died, and he had been married to her for 35 years. It was a long-term marriage, but she had a daughter from a prior relationship, and as a result, the house, which was in her name, had to go through probate, and all he got was a life estate. Daughter didn't want to sell it, and he needed the money, the funds, so that he could get the proper care for pancreatic cancer. I came in, I filed an emergency motion regarding, spousal claim and so forth, whatever I could do to see if we could get something for him. The judge granted the emergency hearing, and she set it for 2 weeks later, and he died before the hearing. And I hate that. I don't want that to happen to you. I don't want that to happen to your loved one, but we need to stop assuming that spouses automatically get everything. Another assumption that I heard today, my client's brother had assumed that if something happened to him and his wife, well, the grandmas will just get the kids. No. Again, there is no like, this is a person and then this person, and that is not a thing. Okay. Anybody who is a Florida resident can petition to be the guardian of your child. And while family sometimes gets priority, that doesn't mean that family is going to be the one appointed. And it might not be the family member that you want. It might be a family member who looks amazing on paper. Okay. They financially organized and so forth, but they are a horrible person and they don't like kids. They're only doing this because they can control whatever funds were left behind for your children. We don't want that. Okay. Assumptions make an ass out of you and me. So let's not do that. The other kind of myth out there is not being able to afford it right now. Listen, very few of us walk around with 400 grand in our pocket to buy a house, but we figure out a way to buy a house. Very few of us walk around with 70 grand to buy a car, but we figure out a way to buy a car because those are priorities. Those are things that we need to do. Estate planning, legacy planning is something that every family needs to do. And it is way less expensive than going with the state's plan. Okay, usually my clients pay about 1/10 of what the state's plan would turn out to be for them. Often less, because if you add incapacitation planning with death, it's just, it's awful. The numbers get way up high. So if you want to talk to my team to see if you'd like to sit down and have that in-depth conversation that we call the legacy planning session, if you want to really figure out where you stand, then go ahead and get your golden ticket. It's a free 15-minute call. Okay. So it's not going to take very much of your day. And again, if you're not a good fit for us, we still want to help you out. We still want to give you some guidance on the type of lawyer, or maybe actually have the information for a lawyer that you can contact to help you out, because we want you to be properly advised. Okay. All right. So thank you for taking the time to be here. You know that tomorrow is not guaranteed. That's why you're here. But you also know that you have deep love and respect for your family and you want things to go well for them. None of us wake up and go, oh my God, I want my mom and dad to have to deal with such litigation on my behalf. I want them to be miserable for years. None of us wake up thinking that. But it's what happens when we keep delaying what we need to be doing. And with my job, when I meet with clients, whether it's for litigation, whether it's for business planning, whether it's for estate planning, is to help get them the clarity as to what needs to be done so they don't suffer consequence A or B or C. But waiting forever to see if an issue goes away, waiting until the right time, those things don't work out. Okay, because there's no guarantee that we'll be around. Okay, so just like Smokey the Bear, things that you can do. Have those important conversations with family. Yeah, I've given you these tools because I want you to have them. I know it's hard to acknowledge that we're vulnerable. I know it's hard to acknowledge that we will be gone one day, but it is better to have those conversations with people that we trust. It is better to work on those relationships that we want to strengthen so that we can have people that we trust support us through these things and our loved ones, than not have them and assume that things will just figure themselves out. They don't. They don't. And us attorneys that litigate know it too well.